All right. Good morning, everyone, and hello and welcome to Unacademy. My name is Aditi Bhatt, and I'll be conducting your session on daily legal current affairs, wherein we will be analyzing today's The Hindu newspaper. All right. So let's start. Uh, so before proceeding further, you can join the Telegram channel for regular updates regarding the classes, and I'm also sharing the PowerPoint presentations and the Hindu newspaper over there for your reference. And I'm also sharing the link and the related documents, important documents which are relevant from your exam point of view. Also, if you're planning to take any of the subscriptions provided by an academy platform, so to unlock the free classes and subscription discounts, you can use the referral code ABCLAT. All right, so let's start. So these are the today's highlights. So today there were several news items which were relevant. All right. So the first news item that we will be covering today is Shraddha murder case, and court frames charges against Aftab, trial to start in June. And then nine gets 7 year rigorous imprisonment in the Delhi riots case. So we'll look into that. Then High Court seeks Khalid Saifi's reply on phone recovery. This case is related to conspiracy, so we will also look into that. Then the fourth news item talks about sub judice cases should not be politicized. So we will see what are sub judice cases, right? And another is where the goal is to keep youth away from drugs. So we'll see what are the international conventions related to drugs and what are the national or what are the domestic laws related to it. Okay. Then Assam plans to ban polygamy. So we'll look into the Uniform Civil Code, polygamy, child marriage, certain such provisions. Okay. The right to health goal and a role for Taiwan. So the right to health is one of the goals under Sustainable Development Goals. So we'll look into what Sustainable Development Goals are. Then the eighth is securing the migrant vote. So the recent proposal by the Election Commission of India to start with the RVMs, that is the remote voting machines. So we will look into that proposal and we'll see what RVMs are. Okay. Then 7 lakh people displaced in Sudan according to the United Nations. So we'll look into there's a crisis going on in Sudan, the war situation, right? And because of that, there's a lot of internal displacement that is taking place. So we'll see what is internal displacement, right, and the related conventions and laws related to it. Okay, then the 10th is court awards 20-year jail term to two for gang rape during Muzaffarnagar riots. Okay, so we'll see the different criminal law reforms that have been implemented or have been added in the IPC, in our criminal law system. Then the 11th news item that we will be covering is Arab trains to carry Indian goods to Israeli port, right? So the Indian goods have okay. So there's a free trade agreement between India and Israel. So we look into what is free trade agreement. This is part of your international law. Then it depends on who is giving the rating. Center on India's rank in Press Freedom Index. So we'll also see what this article talks about. Traditions have not stopped concept of marriage from evolving. This article is related to the same sex marriage. So we will talk about the right to same sex marriage and what the how the case is proceeding. Then the 14th news item that we will be covering is same-sex couples, live-in partners not included in surrogacy law. So we'll see what surrogacy is and what is the law related to it. And 15th is government to start countrywide screening for thalassemia. So this is actually a Niti Aayog proposal. So we'll see what is Niti Aayog. And don't promote e-cigarettes. INB ministry tells media. This is e-cigarettes is also part of drug, and we'll see the regulation related to e-cigarettes in India. Then Sri Lanka's Supreme Court clears path to legalize homosexuality. So we'll see the homosexuality, the right to sexual orientation, evolution in India. All right, and Iran executes more than 10 persons per week, says United Nations. So again, like tomorrow, we look into a comparative criminal law and compare the different criminal justice systems. All right, so let's start. So the first case is Shraddha murder. Court frames charges against Aftab, trial to start in June. So this case is related to, so in this case here, so first of all we'll see the word, it is stated here that prima facie case of murder made out against accused. Prosecution's case relies on DNA analysis of blood and bone samples, witness statements, lie detector test, among other evidence. All right, so we'll see, first of all, the term prima facie, what does it mean? All right, what is prima facie, what does it mean? So prima facie, the Latin term, it is a Latin term which basically means at first sight. It is at first sight, right? All right. It basically means, though, so the term prima facie may be used as an adjective, meaning sufficient to establish a fact or raise a presumption unless disproved or rebutted. Okay. So generally, it is used as, in the context of evidence or prima facie evidence. It may also be used as an adverb meaning on first appearance, but subject to further evidence or information. Right? Okay, now let's look into the sections that have been mentioned here in the article. They've mentioned specifically two sections. That the first is section 302, which provides punishment for the offense of murder, and then section 201 of IPC, which provides punishment for disappearance of evidence. Okay, so 302 of IPC basically states, it talks about punishment of the offender who is guilty of committing murder. So section 302 provides punishment for murder. And where is murder? The offense of murder defined? It is defined under section 300 of IPC. Defines murder. All right. The accused will be tried under this section at the final stage of the proceeding. It states that this particular section, section 302, states that whoever has committed murder shall be punished with either imprisonment for life, that is life imprisonment, or death penalty, right? Both of them, I like either of them, but it will be with fine, depending upon the seriousness of the crime. So this particular punishment is, basically given, awarded as per the case is, right? If the case is, if the facts of the case state that it was a heinous crime, it was heinously committed, and right, like in this case, the girl was chopped to pieces and was kept in the fridge. So this is sort of a, this is a heinous crime, right? So this is not just a simple murder. So anyway, so the court will decide that, and the court will then award either life imprisonment with fine or death penalty with fine. Now generally, so you see death, okay, we'll see the ingredients of murder. So there has to be, first of all, intention has to be proved on part of the accused, right? That there has to be an intention of causing death, right? Then the cause of death, the act must be done with the knowledge that the act may or is likely to cause the death of another. So there has to be knowledge of the fact that this particular act will cause or is likely to cause death of another person, and there has to be bodily injury, right? That the intention must be to cause such bodily injury as is likely to cause death, right? All right. So when it comes to death penalty, so death sentence or capital punishment is awarded only in rarest of the rare cases in India. Death penalty is awarded only in the rarest of the rare cases. Okay. There was this case, Bachchan Singh versus State of Punjab, wherein wherein the court had, sorry, just a second, wherein the Supreme Court had given out this doctrine of rarest of the rare principle. So death penalty is only awarded in the rarest of the rare cases. And another important judgment is Mittu versus State of Punjab, under which it was also laid down by the Supreme Court that the rarest of the rare, the capital punishment or death penalty will only be awarded in rarest of the rare cases, and it will also be seen the mitigating circumstances. What the mitigating circumstances that caused the accused to commit such a crime will also be taken into consideration while awarding death penalty. So it talked about mitigating circumstances. All right, right. So in general, life imprisonment is the rule, and death penalty is an exception. Right, death penalty is only awarded in such crimes where there is, in basically heinous crimes, when you know it is heinously committed the crime. All right. So then we coming to section 201 of IPC. Section 201 of IPC talks about basically it is punishment for disappearance. Just a second. Disappearance of evidence. All right. So the word evidence is derived from the Latin word evidentia, which means to exhibit clear, to make it clear to the eye, to clearly confirm, and to prove, right? Evidence is anything that may be used to establish or reject the existence or non existence of a claimed fact. Section 3 of the Indian Evidence Act also defines the term evidence of Indian Evidence Act. Section 3 defines evidence, right, as statements that court permits to be made by the witnesses relevant to the facts of the case and documents submitted before the court for inspection. This documentary evidence also includes inspection of electronic records. Now, Section 201 of IPC basically it is causing disappearance of evidence of offense or giving false information to screen offender. Right. So 201 basically punishes for causing disappearance of evidence of offense or giving false information to screen offender. This section comprises of two aspects, which include disappearance of evidence and giving false information with the intention of screening the offender from legal consequences. Okay, so in this case, there was clear disappearance of events. The evidence was hidden, and or it was hidden, or it was, basically it was made to disappear, and there are two essential criteria for this section to be applicable. Firstly, the accused should have had knowledge or reason to believe that an offense has been committed. So, accused had knowledge that an offense has been committed. Secondly, he should have then caused the disappearance of evidence of the commission of that offense, or should have given false information. Then the person or the accused causes disappearance of evidence. All right, so these are the two ingredients. The offense must have been committed. A person must induce the disappearance of any evidence of the crime committed, and it must be done with the goal of screening or sparing the offender from punishment. So the other ingredients are that the offense must have been committed. A person can either he can or she can, basically whoever is the accused, can disappear the evidence or cause the disappearance of evidence himself or herself, or can even induce the disappearance of any evidence, or can actually ask anyone else to uh, cause the disappearance of evidence of the crime committed. And it has to be done with the goal of screening or sparing the offender from punishment. All right, so this is what the article basically deals with. So these are the two sections mentioned under the news item. Okay, then moving ahead, this is a news item. It states nine get 7-year rigorous imprisonment in Delhi riots case. So we'll look into, first of all, there are two things: rigorous imprisonment and rioting. Okay, so we'll see what are the okay. So section 53, when we talk about punishment, rigorous imprisonment is a kind of punishment that is mentioned under IPC. So section 53 of IPC provides for different types of punishment. Okay, first is the capital punishment or the death sentence, right? Then provides for life imprisonment, LI, life imprisonment, and then imprisonment is of two types. First is the simple imprisonment, and then there is rigorous imprisonment, right? And it is also generally, depending on case to case, sometimes the judges also award solitary confinement to those individuals who are serving rigorous imprisonment, depending on the case to case. Solitary confinement is also awarded. And then there is a forfeiture of property and fine. So these are the different types of punishments that are mentioned under IPC, right? And the difference between simple and rigorous imprisonment is that rigorous imprisonment also is basically it comes with hard labor. All right. Okay. Now, when we are talking about another issue here is riot or rioting, right? So this is an offense that is covered under offenses against public tranquility under IPC. Offenses against public tranquility. Okay, and then so there is a difference. Generally, students get confused between unlawful assembly, unlawful assembly, then rioting, and affray. So we'll see what these three are and try to distinguish between them. So unlawful assembly is unlawful assembly, or UA generally, it is section 141 of IPC deals with unlawful assembly. It talks about five or more than five persons who are basically five or more persons commit an unlawful offense called unlawful assembly. An important aspect of unlawful assembly is presence of common intention. So there is a common intention uh, to disturb public peace and tranquility. The mere presence of person in assembly without any motive to infringe the peace in surrounding is not punishable. So the common objective is to determine aim and nature of assembly, right? Then another thing is rioting. So rioting is covered under section 146 and 147, right? So the only difference between rioting and unlawful assembly is use of criminal force basically. Under rioting there is a use of criminal force, and in unlawful assembly there's no use of force, but both of them include five or more than five people, and they have a common intention, and the object can be to disrupt public peace and tranquility, right? to um, to use criminal force against any public servant, state or central government, to resist any legal proceeding, to commit any mischief or trespass on any property or person, right? To commit criminal force against any person to deprive him of the enjoyment of any right. Okay, so basically rioting is equal to unlawful assembly just a second. Okay, writing this is equal to sign. Okay, so writing is equal to unlawful assembly plus violence. Okay, and what is affray? The difference between writing and an unlawful assembly and affray is, so affray first of all it is covered under 159 and 160 of IPC, and it basically deals with two or more persons. So the number of people in affray are lesser than what it is in rioting or unlawful assembly. Affray refers to fighting in public so that it disturbs the public order and peace. For affray to take place, the presence of two or more persons is must, and their action should negatively affect the tranquility in their surrounding. However, most importantly, the effect of their behavior should create disorder in society or for the people, right? So if it's a smaller scale, if there is fighting between two three people, so it's a smaller level, so that would constitute an affray. So just a riot is basically a violent outburst of an unlawful assembly. So when an unlawful assembly violently outburst, like what happened in Manipur, so it was a clear case of riot. So Manipur riots, right? And then it would basically constitute rioting if there is a violent outburst of an unlawful assembly. Or and on the other hand, an affray is when there is a violent activity that took place in public to disturb public peace. Okay, between two or more people, but it should be less than five. uh, Riot can be committed in both public and private settings, but affray can only be committed in public arena, right? For rioting, five or more people must be involved, and for affray, two or more than two is sufficient. Now there is a presence of common object in rioting, right? And but there is no presence of common object when it comes to an affray, right? Every member of an unlawful assembly is liable for the offense committed even if he has not done any act under rioting. And when it comes to affray, the person who has actually committed the offense of affray is liable. Okay, so I hope you understood the difference between all these three. Okay, so we'll move ahead. Now, another case basically, it uses the term conspiracy. So let's see what conspiracy deals with under criminal law. So, conspiracy is basically catered or basically dealt with under IPC in section 120 capital A and 120 capital B of IPC. So, 120A, section 120A defines criminal conspiracy as an agreement of two or more persons, agreement of two or more persons to do or cause to be done, to do or cause to be done an illegal act or an act that is not illegal but by illegal means, and either they are committing an illegal act or they are committing a legal act but by illegal means, right? Section 43 of the IPC defines what is illegal. 43 of IPC defines the term illegal. Okay. It states that as everything that is an offense or is prohibited under IPC or furnishes ground for civil action is basically that's what illegal stands for. Now, there is a proviso attached to section 120A which states that a mere agreement to commit an offense shall amount to criminal conspiracy and no overt act or illegal omission is required to be proved, right? So there has to be like two or more persons to who agree, two or more persons to who agree to do or cause to be done an illegal act. By illegal means there must be at least two persons who conspire, so there have to be two people who can conspire, right? Then joint evil intention to do an illegal, there has to be a joint or criminal intention to do an act, illegal act or an act that is not illegal by illegal means. So, and 120B basically talks about punishment for criminal conspiracy. So punishment for criminal conspiracy, where the criminal conspiracy is to commit a serious offense. In this case, the criminal conspiracy is basically punishable with death, imprisonment of life, or rigorous imprisonment for a term of 2 years or more. And right, it depends from case to case. So the punishment can be either death or life imprisonment or rigorous imprisonment for 2 years or more, right? Depending on the case to case, the facts of the case, basically. And if there is no punishment expressly provided for criminal conspiracy, then that person shall be punished in a manner as if he had abetted such offense. All right. Uh, Criminal conspiracy to commit offences other than those covered in the first category. Whoever is party to such a criminal conspiracy shall be punished with imprisonment of either description of a term not exceeding 6 months or with fine or with both. Okay, so depending on the case, depending on the facts of the case, the judges can award punishment under criminal conspiracy. Okay, now next news item is related to sub judice. state sub judice cases shouldn't be politicized. So we'll look into what is sub judice. So these are civil law concepts and a general understanding of these, because these terms, these are Latin terms which are very they are in usual they are generally used by people. So an understanding of what these terms means is important for you. Okay, so sub judice or res sub judice, this is basically a doctrine, right, which means under judgment. Under judgment, it denotes that a matter or a case is being considered by court or judge when two or more cases are filed between the same parties on the same subject matter, right? Basically, whenever there is a case which is already going on, which is still under consideration by the court, okay, it is still pending. In that case, it is called sub judice. That the case is sub judice. So in this case, our Home Minister is basically saying that sub judice cases shouldn't be politicized. That is, they are still under consideration by the court of law, and that if they are under consideration, then they shouldn't be politicized. And another term, another doctrine. So this is first was doctrine of res sub judice. Second is the doctrine of res judicata. Okay, so with sub judice, you should also understand res judicata. Basically, this is a Latin expression or term which means matter once adjudicated cannot be re-adjudicated. Matter once adjudicated cannot be re-adjudicated. All right. The doctrine of res judicata technically means that a matter is issue which has already matter in issue which has already been tried by competent court, right? Then trial between same parties in respect of same matter will not be allowed. Okay, so the rule of res judicata is basically is based upon the principle that no person, principle says that no person should be vexed twice for the same cause of action, for the same cause of action, right? Even our constitution provides that, right? Under section, or sorry, our constitution provides that under article 20 clause 2, right? The doctrine of double jeopardy. Okay, all right. So I hope this is clear. If you have any doubt or any questions related to any of the articles or news items that we are covering, you can mention it in the comment section below. Okay, so the next news item that we are dealing with is where the goal is to keep youth away from drugs. So now we're going to analyze. Now this article actually mentions UNODC, which stands for, yeah, UNODC stands for United Nations Office on Drugs and Crime. So we'll see what UNODC is. So from international law, it is important. Also from the point of view of from the point of view of criminal law and domestic law, it is important, right? It also mentions the National Action Plan for Drug Demand Reduction. And under criminal law, we have an ancillary law Okay, we have several ancillary statutes which are also part of your criminal law. So having an understanding of those ancillary laws is also very important. So here we'll be covering the NDPS Act, or the Narcotic Drugs and Psychotropic Substances Act. So what is UNODC? UNODC stands for United Nations Office on Drugs and Crime. All right, this was established in 1997 and was named as UNODC. This was earlier established, basically it was renamed in 2002 as United Nations Office on Drugs and Crime. Um, it acts as the Office for Drug Control and Crime Prevention by combining United Nations International Drug Control Program and the Crime Prevention and Criminal Justice Division of the United Nations Office in Vienna. Right? So we have 26th June, which is celebrated as the International Day Against Drug Abuse and Illicit Trafficking. Right? So every year we celebrate 26th June as the International Day Against Drug Abuse and Illicit Trafficking. All right. Now India is a signatory to the to the conventions, that is the UNODC. So there are three conventions, right? There's a single convention on narcotic drugs, which was in 1967. Single convention on narcotic drugs, 1967. Then there was the convention on psychotropic substances in 1971, and there in 1988 the convention, or the United Nations Convention against illicit traffic in narcotic drugs and psychotropic substances. And India is a signatory to all three. Right? And therefore in India we have the NDPS Act, which is the NDPS Act. Okay, so first of all, let me tell you why India is vulnerable when it comes to the problem of drugs, or the menace of drug. Why is India so vulnerable? Actually, India is sandwiched between six countries which are major opium production regions. Okay, so what are those six countries? um, Six countries, and basically they are called Golden Crescent and Golden Crescent. This is just for your general information. Golden Crescent and Golden Triangle, just for your extra information. All right. The six countries that are major opium producing countries are Afghanistan, then Iran, Pakistan. They form the Golden Crescent, right? And on the other hand, this is on the western frontier, western side of India, and on the eastern side we have the borders of Thailand and then Myanmar and Vietnam. Right? So these are six countries which are major opium producers, and which is why India, there's a lot of threat when it comes to drug abuse, drug trafficking, illegal trafficking, and another is that India becomes very vulnerable, right? Because in India, the demography of India is such that the age group between 15 to 35, is the part of majority population in India currently. So that's why it has more and more young people, right? Youngsters are more, so they are more vulnerable to such you know menace in the society. So let's talk about the NDPS Act. The NDPS Act stands for Narcotic Drugs and Psychotropic Substances Act, right? The act provides for stringent measures and control and regulation of operations relating to narcotic drugs and psychotropic substances. Narcotic drugs and psychotropic substances, right? Narcotic drugs are basically chemically produced drugs, right? They are chemically produced, and the psychotropic substances are the such plants, or which are naturally produced, naturally available, right? So, and for NDPS Act, where the punishment for offenses under NDPS Act is death penalty. All right, in cases if the person is a repeat offender. Okay, now, all right, so we'll move on. Assam plans to ban polygamy. Now, this article talks about Uniform Civil Code, it talks about child marriage, it talks about polygamy, right? So, all of this is basically, you can say that there is an overlapping. This is an article which has issues of both constitutional law as well as family law, right? So, Uniform Civil Code, or the UCC is mentioned under Article 44 of the Constitution of India, which is a directive principle of state policy. Is a matter of public policy that no direction in this regard can be issued by the court. Basically, the center recently also has requested the Law Commission of India to undertake examination of various issues relating to